Moving on to freedom of speech. It's actually one of my favorite topics. I teach the First Amendment in my media law class in the communications department, and I spend a lot of time on freedom of speech. You guys are going to get a little snapshot of this amendment as it relates to criminal prosecution of people based on their speech. And First Amendment, 45 little words: Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech, press, right for folks to peacefully assemble, and to petition the government for redress of grievances. And we're going to talk about the speech component, but just say, in case you're asked a trivia question, certainly there's 5 rights here in this one amendment. And I'm sure you're familiar with the first 4 we read off, but the last one always gums people up. The right to petition the government for a redress of grievances. What that is one, you can go and call up your congressman, or write a letter to your politician who is sitting as the speaker of the community for that community they represent, and state your issues, whether you agree what's going on or not agreeing what's going on, or maybe we need a law for this. You can do those things without getting punished. The other thing you can do is if the government does something to you, you have the right to sue the government without being punished. So that's what that component means. Let's look at the history of this freedom of the speech / press. Because really speaking and printing didn't really happen until the 16th, 17th century, when we were able to get the word out, so to speak, when the printing press came. And then, our neighbors, they spoke to each other and so forth, but you really couldn't get the word out, not until the printing press came along, and then the government began to censor the press. And then came from that was censoring speech. Why would the government want to regulate speech or the press? They were afraid that the press would weaken their power or their authority, or create an uprising. So the British really restricted the press, and as we became a country, the United States became a country, or America became a country, in the early times there was kind of some restriction in keeping some of the press and the speech. And prior to our Constitution, there were several types of laws: seditious libel laws, they called them, laws to punish those who criticized the government, regardless of what you were saying about them was true or false. Certainly if you say something that's false about someone, that's a different kind of action, defamation. I'm sure you've heard that. But they would criminalize speaking about the government, and there are lots of countries that still do that. Thankfully, we're not one of those, as you can tell from all the stuff that gets posted on social media. So the freedom to speak and to print carried its way over to colonial America until we had our first challenge. Before the Constitution, there was a man who owned a magazine, the New York Weekly Journal. His name was John Peter Zenger, and he was writing about the opposition vote to the unpopular governor. And there was a law that says you can't criticize government officials in New York. So he was arrested and he was charged with that law. He was prosecuted. The law basically said that you can't publish unfavorable criticism about the government. And his defense attorney, who was John Adams before he was the president, argued, yeah, he violated this particular law. I mean, it's obvious. He printed you couldn't deny the fact that he was publishing unfavorable criticism about the government, but his attorney argued that no man should be imprisoned or fined for publishing criticism of the government that was truthful and fair. And this was kind of our stepping stone to freedom of speech and freedom of the press, when the jury came back with a not guilty verdict, obviously against what the law said. But the law said this: aren't you supposed to follow the law, jury? And yes, but the jury does have this one concept that's not really talked about much in courts. Attorneys can't talk about it, certainly today. They can't bring it to a jury's attention, neither can the judge. But there's this concept called jury nullification, and that's when the jury ignores the law and returns a verdict in according with their conscience of what should be, this is the right thing to do. And hence, you know, freedom of speech made its way into the Constitution after, not right after that case, but shortly thereafter. So, what is speech? It could be something that's spoken, be something that's written, could be a photo, could be a painting, it could also be symbolic, based on somebody's conduct, burning of a flag. We've already touched on that a little bit. Is this automatic when a person's conduct will be deemed speech? Not necessarily. The conduct, the intent of the person doing the conduct, his or her intent has to be to display some sort of message, and the audience has to perceive it as such a message. So, for instance, let's take the flag burning at a protest. We're burning the flag, we're protesting the war, whether, you know, it was Vietnam at the time when this was very big, flag burning, but people still do it. Flag burning, it's political. You get the message, right? How about nude dancing at a strip club? There was laws that were passed regarding no strip clubs. And the court said, no, that's a form of symbolic speech, nude dancing. Riding a bike naked at the World Naked Bike Ride protest was not obscene. They were protesting against the use of gas in cars. That was a political message. You know, wearing a shirt with a political message on it. Horn honking. There was a statute that forbid horn honking in a vehicle that had to be done only in emergency situations. That was the law. And could you see where there could be a problem with that? Or emergency situations. So the only time you can honk your horn is an emergency situation, to get, you know, another car out of the way, or maybe there's a pedestrian that's about to cross. What about all those other times we honk our horns? You know, in a parade, in a wedding, people are driving down honking horns. That is speech, so that law was deemed unconstitutional. And I feel like I have a typo in my what is speech thing. Look at that. Very bad typing there. How about flipping off a police officer? Can you give a police officer the finger? Is it speech? There was a law that says that you could not do that. It would be obstruction of justice. It's disorderly conduct, I'm sorry. The law made it disorderly conduct to flip off a police officer. And that was deemed unconstitutional in that it's political, symbolic speech. Now, unless you're actually getting involved in what they're doing, that's another problem. But if you're just cruising down the, street and you stick your finger out the window, flip off a police officer, they cannot come and arrest you. I don't advise that you do that because it's kind of disrespectful. But nonetheless, it is not something that you can be charged with. All right, let's talk about these laws a little closer here. I said the last time, I think we've all agreed, even though I can't see you, that we do not have an absolute right to speak whatever we want, whenever we want, however we want. There is some fine line. There are very few fine lines, but there's some fine lines nonetheless. And the first time the Supreme Court visited this area of where you can be arrested, charged with a crime for speaking, was in this 1919 case. And this is where that concept of you can't yell fire in a theater comes from. And there wasn't a case where somebody went running into a crowded theater and screamed fire. What happened was this was a political type case. They usually are involving politics. But Socialist Party authorized this guy, Mr. Schenck, to publish leaflets protesting the U.S. involvement in World War I. The pamphlet described the war as cold-blooded and urged men to resist the draft. So the government prosecuted him and others under the Espionage Act, which says you can't talk bad about the war in the United States. I'm paraphrasing, but that's what the gist is. The case made its way to the Supreme Court because certainly he was convicted, found guilty, and had to serve some sort of punishment. And he argued that it's his First Amendment right to free speech, to be able to do that. And the court said, and the judge, when the judge made the ruling, or when the court made the ruling, one of the judges said, yeah, but you don't have an absolute right. If you are going to create something that is called a clear and present danger, kind of like, and he used the example, kind of like yelling fire in a theater, that's not free speech. So they created this test, whether the words used in such circumstances and are of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. So it's kind of a question of proximity and degree. Does that make any sense? Do we really know? This is, again, what thanks court, but what's really clear and what's present and what's danger? But unfortunately, this was the law for a while, until 1969. And we touched on this case, the Brandenburg versus Ohio. And this is the law in its current state. It hasn't changed. The Supreme Court hasn't visited this. This is the last time that they heard a challenge to a seditious law. And that, you know, I think I explained it, but I'm going to say it again. A seditious law is when the government tries to pass laws that restrict speaking, especially criticizing the government. So I'm going to tell you a little bit more about this case and give you the details, and we talked about it in the last slide. I'm going to do that right now. So what happened here was there was the leader of the Ku Klux Klan who was prosecuted and convicted of violating an Ohio law for stating, quote unquote, we're not revengeful, we're not a revengeful organization, but if our president, Congress, Supreme Court continues to suppress the white Caucasian race, it's possible there might have been some revenge taken. And he was prosecuted, convicted, and he appealed all the way up to the Supreme Court. And the court overturned the conviction. It says the constitutional guarantees of free speech and free press do not permit a state to forbid or prescribe advocacy of the use of force or of the law violation except where such advocacy is directed to inciting or producing imminent lawless action and is likely to incite and produce such action. So basically, the court said you are free to advocate the use of force, and, you know, talk about the use of force and violating the law and overthrowing the government. You can talk about it all you want, but what you can't do is direct it. Did the speaker actually intend for his words to incite lawless action? Directed. Was it imminent, that lawless action? Is the time between the speech in question and the lawless action very close and proximate? Is it the conduct lawless action? Is there a law in place? And is it likely? Is the action likely to occur? Is the action substantially likely to occur and not merely speculative result of speech? So basically inciting a riot, okay? You can't incite a riot. If you incite a riot, you can be prosecuted. And even if you do that with your speech, you won't be protected. It won't be protected speech. Advocacy is okay. You can be a member of a communist party or any sort of organization, stand in a public park with your message and have groups get together and discuss overthrowing the government. You're free to do that. You can't incite a riot. You might recall what had happened in Charlottesville. That would be actions inciting lawless action. Now, I won't delve into that, but that's an example I'm putting out there for you. So that is the criminal aspect of speech. If you're going to incite a riot, you're not going to be able to claim free speech. Let's talk about this other area, hate speech. These are words, here's the definition, words written or spoken that attack, insult, degrade individuals or groups because of their race, ethnic background, religion, gender, or sexual orientation. And my question is hate speech afforded First Amendment protection when printed, broadcasted, painted on walls? What do you guys think? Is hate speech protected? Most folks say no, affirmatively no, but the answer is yes. It is protected speech. Hate speech is protected speech. Someone can say whatever they want about a particular race, gender, etc. You're free to do that. It's just like you're free to advocate overthrowing the government. But let's break it down. Face-to-face. What about speech that's face-to-face? We call those fighting words. And this is a very old case, but it's still the law. And when I read you the facts, you might giggle, because nowadays, if this occurred, we wouldn't be talking about face-to-face fighting words. But in 1942, Mr. Chaplinsky, who was a Jehovah's Witness, was using the public sidewalk as a pulpit in downtown Rochester. He was passing out pamphlets and calling organized religion a quote-unquote racket. After a large crowd had begun blocking roads and generally causing a scene, a police officer removed him and took him down to the police station. At the station, Chaplinsky verbally attacked the police officer. He was arrested for shouting, quote-unquote, "You are a goddamn racketeer and a goddamn fascist." He was convicted, and his case was appealed all the way to the U.S. Supreme Court. And the question was, did the statute or the application of the statute to Mr. Chaplinsky's comments violate his free speech rights under the First Amendment? And the court said no. These are fighting words. These are not protected by free speech. Fighting words are words that inflict injury and tend to incite an immediate breach of the peace. Not to be confused with insults. Insults that offend only if they give rise to a breach of peace. So if you call somebody a name, unless your intent is to incite a fight, it's not going to be, that's going to be protected. But I want to be clear that we're talking about speech, fighting words, that's personal, and face-to-face encounter. And I put in parentheses here, a true verbal threat, okay? I note some cases in my slides. They're not in the reading material. It's just where these points come from. You don't need to know the case, just some of the points. So words that have a direct tendency to cause acts of violence by the person to whom individually the remarks are addressed. So if your intention is to incite a reaction, then that is going to be deemed fighting words. Your words might be related to hate speech and those types of things, but if your intent for doing that is not, it's not going to be protected speech. The swearing at members of a government committee to express frustration with their actions constitute fighting words. And that case there, Klen versus City of Loveland, kind of had these two guys. They were two contractors. They were waiting to get approval from a government committee so they can get their job rolling, but the government committee was kind of sitting on things. So they'd go in and they would call them, you know, goddamn this, and, you know, you guys are slackers, and, you know, swearing and using offensive language. But the court said no, that was not fighting words. That was just an example of frustration. There was nothing else behind it but their words of name calling and being insultive. Compared to this case, the Kansas Medeers case, where it involved a husband and wife, estranged husband and wife. They were going through a divorce, and the husband continued to yell obscenities and names in front of their child to the woman, and made comments of he should, you know, take her out, and, you know, she'd be better off dead. And that was a fine line of actual threat of violence. While it's not required, it's merely a factor, that could be towards fighting words when he argued, oh, those were just my words, it's free speech. There's a fine line, and the point is, what is the context it's being said in? And let's take some symbolic speech with this hate speech. What if it's an attempt to communicate a hateful message? Is it protected? It is protected if it's communicating a hateful message. Let me talk to you about some. I don't know if I have a slide on that one. Oh, yeah, I do. All right. This case from 1978. And then we have a case from 1992. We have a National Socialist Party who wants to march down the street in a parade flashing their swastikas. And this village is a Jewish community. And the town wanted to stop it, which they did. They didn't allow them to have their permit to do their parade. So they appealed all the way up to the Supreme Court. And the Supreme Court says, yeah, it may be unfavorable to see the swastika displayed, but it's protected speech. And they're allowed to march peacefully down the street waving the swastika. The same thing with the burning of the cross. Burning of the cross in and of itself does not violate free speech. And my two cases on that is this one, RAV versus St. Paul. There was an ordinance that forbade the display of a burning cross or Nazi swastika or any writing or picture that arouses, that, this is the key language, quote unquote, that arouses the anger, alarm, or resentment in others on the basis of race, color, creed, or gender. And our Supreme Court said, and this was somebody put a cross on their neighbor's property and lit it on fire. The court said this law violates First Amendment. This is beyond content from discrimination. It's not aimed at one particular person. And this language in and of itself arouses the anger, alarm, or resentment in others on the basis of race, color, creed, or gender. Can do what? We talked about vague and overbroad and reaching. This is very subjective, right? Arouses anger, alarm, or resentment in others. So the court said, yeah, this is not, we get what you're trying to do, but this restricts speech. Now, in that example that I gave you, or the facts of the case, it does not mean the person didn't get in trouble for lighting a cross up on fire in somebody's yard. There could be a different kind of charge, but not under this particular statute, which said you can't display a burning cross or a Nazi swastika or any writing or picture that arouses anger. It's too subjective, too far-reaching. However, if you burn a cross that constitutes some sort of threat, then it's not going to be protected. Virginia versus Black was our Supreme Court case in 2003 that said burning of the cross is not protected if it's done with the purpose to intimidate. This crossed the line for a hate crime. Our defendant, Black, was prosecuted and convicted for burning the cross. The Virginia statute banned cross burning with the object of creating fear or intimidation in a person or group. The court said burning the cross doesn't infringe on the First Amendment so long as the state made it a crime to burn the cross with the purpose to intimidate the victim. So this case kind of brings us to another category of speech that is not protected, and that is the true threats of violence. Those statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence to a particular individual or groups of individuals. Oops, let me get you to my true threat. So, intimidation is a type of true threat. So what's our difference between the cases in Chaplinsky and Black here? Do you have to have face-to-face? In Chaplinsky, we had face-to-face communication. In Black, we don't. It's symbolic speech. But we still have some form of intimidation. We have the one that's directed face-to-face. Those are fighting words. And then we have something that constitutes a true threat. I'm going to link as one of the assignments for this week a case involving internet threats. Prosecutor's job to prove beyond a reasonable doubt that word intent. Because how do you know somebody intends, right? You need an intent. True threats here are, those statements where the speaker means to communicate a serious expression of an intent to commit an act of unlawful violence. So I want a case that went all the way up to the Supreme Court that involves Facebook postings. I'm going to make that part of this week's forum post. So I'll have you analogize that. So that's my snapshot on criminal laws involving criminalizing speech, a person's speech, when it can happen, when it cannot happen. But there are very limited laws relative to free speech. These are the main ones: fighting words, true threats, inciting a riot. Other ones, you don't particularly have to know, but I'm going to tell you them anyway. Libel, right? When you say something false about somebody else, those aren't protected speech. Child pornography is not protected speech. And obscenities, things that are considered an obscenity, are not protected speech. But that's the class. Otherwise, it's pretty, you have, a lot that's covered under the category of free speech that can't be criminalized. So next, we're going to move on to a few other constitutional amendments that'll finish up our discussion on constitutional protections.